Part 3 of Remedial Law Bar Q&A as syllabus sequenced. Let's pick up from Procedure in Regional Trial Courts, Rule 6 to 39. 2004. PX filed a suit for damages against DY. In his answer, DY incorporated a counterclaim for damages against PX and AC, counsel for plaintiff, in said suit, alleging in said counterclaim inter alia that AC, as such counsel, maliciously induced PX to bring the suit against DY despite AC's knowledge of its utter lack of factual and legal basis. In due time, AC filed a motion to dismiss the counterclaim as against him on the ground that he is not a proper party to the case, he being merely plaintiff's counsel. Is the counterclaim of DY compulsory or not? Yes, the counterclaim of DY is compulsory because it is one which arises out of or is connected with the transaction or occurrence constituting the subject matter of the opposing party's claim and does not require for its adjudication the presence of third parties of whom the court cannot acquire jurisdiction. Should AC's motion to dismiss the counterclaim be granted or not? The motion to dismiss for plaintiff's counsel should not be granted because bringing in plaintiff's counsel as a defendant in the counterclaim is authorized by the rules, where it is required for the grant of complete relief in the determination of the counterclaim. The court shall order the defendant's counsel to be brought in since jurisdiction over him can be obtained. Section 12 of Rule 6, Aurelia v. Court of Appeals. Here, the counterclaim was against both the plaintiff and his lawyer, who allegedly maliciously induced the plaintiff to file the suit. Alternative answer: the counterclaim should be dismissed because it is not a compulsory counterclaim. When a lawyer files a claim for a client, he should not be sued on a counterclaim in the very same case he has filed as counsel. It should be filed in a separate and distinct civil action. Chavez v. Sandiganbayan. 2000. X files a complaint in the RTC for the recovery of a sum of money with damages against Y. Y files his answer denying liability under the contract of sale and praying for the dismissal of the complaint on the ground of lack of cause of action because the contract of sale was superseded by a contract of lease, executed and signed by X and Y 2 weeks after the contract of sale was executed. The contract of lease was attached to the answer. X does not file a reply. What is the effect of the non-filing of a reply? Explain. A reply is generally optional. If it is not filed, the new matters alleged in the answer are deemed controverted. Section 10 of Rule 6. However, since the contract of lease attached to the answer is the basis of the defense, by not filing a reply denying under oath the genuineness and due execution of said contract, the plaintiff is deemed to have admitted the genuineness and due execution thereof. Section 7 and 8, Rule 8. Toribio v. Vidin. What is a counterclaim? A counterclaim is any claim which a defending party may have against an opposing party. Section 6, Rule 6. Distinguish a counterclaim from a cross-claim. A counterclaim is distinguished from a cross-claim in that a cross-claim is any claim by one party against a co-party arising out of the transaction or occurrence that is the subject matter either of the original action or of a counterclaim therein. A counterclaim is against an opposing party, while a cross-claim is against a co-party. Section 8, Rule 6. 1997. B and C borrowed $400,000 from A. The promissory note was executed by B and C and adjoined in several capacity. B, who received the money from A, gave C $200,000. C, in turn, loaned 100,000 out of the 200,000 he received to D. In an action filed by A against B and C with RTC of Quezon City, can B file a cross-claim against C for the amount of 200,000? Yes. B can file a cross-claim against C for the amount of 200,000 given to C. A cross-claim is a claim filed by one party against a co-party arising out of a transaction or occurrence that is the subject matter of the original action or a counterclaim therein, and may include a claim that the party against whom it is asserted is or may be liable to the cross-claimant for all or part of a claim asserted against the cross-claimant. Section 8, Rule 6. Can C file a third-party complaint against D for the amount of 100,000? No. C cannot file a third-party complaint against D because the loan of 100,000 has no connection with the opponent's claim. C could have loaned the money out of other funds in his possession. Alternative answer. Yes, C can file a third-party complaint against D because the loan of 100,000 was taken out of the 200,000 received from B, and hence, the loan seeks contribution in respect to his opponent's claim. Section 11 of Rule 6. Rule 7, Parts of a Pleading, or Parts of Pleadings, 2016. Taylor's Toto, Nelson, and Yen filed a special civil action for certiorari under Rule 65 from an adverse decision of the National Labor Relations Commission, or NLRC, on the complaint for illegal dismissal against Empire Textile Corporation. They were terminated on the ground that they failed to meet the prescribed production quota at least 4 times. The NLRC decision was assailed in a special civil action under Rule 65 before the Court of Appeals. In the verification and certification against firm shopping, only Toto signed the verification and certification, while attorney Arman signed for Nelson. Empire filed a motion to dismiss on the ground of defective verification and certification. Decide with reasons. The motion to dismiss should be granted. The verification and certification of non-form shopping were not signed by all the petitioners. There was no showing that Toto or attorney Arman were duly authorized by the other petitioners through a special power of attorney to sign on their behalf. Hence, the motion to dismiss should be granted. Suggested answer. The motion to dismiss should be denied because there is substantial compliance of the requirements of the rules. Verification is not a jurisdictional but merely a formal requirement which the court may motu proprio direct a party to comply with or correct, as the case may be. On the other hand, regarding the certificate of non-form shopping, the general rule is that all the petitioners or plaintiff in a case should sign it. However, the Supreme Court has time and again stressed that the rules in form shopping, which were designed to promote the orderly administration of justice, do not interdict substantial compliance with its provisions under justifiable circumstances. As ruled by the court, the signature of any of the principal petitioners or principal parties would constitute a substantial compliance with the rule on verification and certification of non-form shopping. And should there exist a commonality of interest among the parties, or where the parties file the case as a collective, raising only one common cause of action or presenting a common defense, then the signature of one of the petitioners or complainants acting as a representative is sufficient compliance. Irene Marcos Araneta versus Court of Appeals. Evidently, Since there is a commonality of interest among Taylors, Toto, Nelson, and Yan Yan, there is substantial compliance with the rules on verification and certification against forum shopping when Toto signed the verification and certification and attorney Armand signed the same for Nelson. 2015. Aldrin entered a contract to sell with Neil over a parcel of land. The contract stipulated a $500,000 down payment upon signing and the balance payable in 12 monthly installments of $100,000 each. Aldrin paid the down payment and had paid 3 months installments when he found out that Neil had sold the same property to Yuri for $1.5 million paid in cash. Aldrin sued Neil for specific performance with damages with the RTC. Yuri, with leave of court, filed an answer in intervention as he had already obtained a TCT in his name. After trial, the court rendered judgment ordering Aldrin to pay all the installments due, the cancellation of Yuri's title, and Neil to execute a deed of sale in favor of Aldrin. When the judgment became final and executory, Aldrin paid Neil all the installments, but the latter refused to execute a deed of sale in favor of the former. Aldrin filed a petition for the issuance of a writ of execution with proper notice of hearing. The petition alleged, among others, that the decision had become final and executory, and he is entitled to the issuance of the writ of execution as a matter of right. Neil filed a motion to dismiss the petition on the ground that it lacked the required affidavit against forum shopping. Should the court grant Neil's motion to dismiss? No. The motion to dismiss should be denied because certification against forum shopping is only required in a complaint or other initiatory pleading. Section 5, Rule 7 Rules of Court, Arquisa v. CA. Since the petition for the issuance of a writ of execution is not an initiatory pleading, it does not require certification against forum shopping. B. What is Aldrin's remedy? Aldrin may move for the issuance of a court order directing the execution of the deed of sale by some other person appointed by it. Under Section 10, Rule 39 of the Rules of Court, if a judgment directs a party to execute a conveyance of land or personal property, or to deliver deeds or other documents, or to perform any other specific act in connection therewith, and the party fails to comply within the time specified, the court may direct the act to be done at all costs of the disobedient party by some other person appointed by the court, and the act, when so done, shall have like effect as if done by the party. If real or personal property is situated within the Philippines, the court, in lieu of directing a conveyance thereof, may be an order divests the title of any party and vest it in others, which shall have the force and effect of a conveyance executed in due form of law. The phrase "some other person appointed by the court" may refer to the branch clerk of court, sheriff, or even the register of deeds, and their acts, when done under such authority, shall have the effect of having been done by Neil himself. Alternative answer: Aldrin may also move that Neil be cited for contempt because his obstinate refusal to comply with the judgment of the court to execute a deed of sale. 2014. Mr. Humpty filed with the Regional Trial Court a complaint against Ms. Dumpty for damages. The RTC, after due proceedings, rendered a decision granting the complaint and ordering Ms. Dumpty to pay damages to Mr. Humpty. Ms. Dumpty timely filed an appeal before the Court of Appeals, questioning the RTC decision. Meanwhile, the RTC granted Mr. Dumpty's or Mr. Humpty's motion for execution pending appeal. Upon receipt of the RTC's order granting execution pending appeal, Ms. Dumpty filed with the CA another case, this time a special civil action for certiorari assailing said RTC order. Is there a violation of the rule against forum shopping, considering the two actions emanating from the same case with the RTC were filed by Ms. Dumpty with the CA? No, there is no violation of the rule against forum shopping. Forum shopping applies when two or more initiatory pleadings were filed by the same party. This is discernible from the use of the phrase commenced any action or filed any claim in Section 5, Rule 7. Here, the first case involves the filing of Ms. Dumpty of a notice of appeal which is not an initiatory pleading. Hence, there is no forum shopping. 2009. Amor Solo, a Filipino citizen permanently residing in New York City, filed with the RTC of Lipa City a complaint for rescission of contract of sale of land against Brigido, a resident of Barangay San Miguel, Santo Tomas, Batangas. The subject property, located in Barangay Talisay, Lipa City, has an assessed value of 19,700. Appended to the complaint is Amor Solo's verification and certification of non-forum shopping, executed in New York City, duly notarized by Mr. Joseph Brown, a notary public in the state of New York. Brigido filed a motion to dismiss the complaint on the following grounds. The verification and certification of non-forum shopping are fatally defective because there is no document. Rule on the foregoing ground with reason. The ground raised questioning the validity of the verification and certification of non-forum shopping for lack of certification from the Philippine consulate in New York authenticating that Mr. Brown is duly authorized to notarize the document is likewise without merit. The required certification alluded to pertains to official acts or records of official bodies, tribunals, and public officers, whether in the Philippines or of a foreign country. The requirement in Section 24, Rule 132 of the 1997 rules refer only to paragraph A of Section 29, which does not cover notarial documents. It is enough that the notary public who notarized the verification and certification of non-forum shopping is clothed with authority to administer oath in that state or foreign country, accompanying certification issued by the Philippine consulate in New York, authenticating that Mr. Brown is duly authorized to notarize. 2007, RC filed a complaint for annulment of the foreclosure sale against Bank V. In its answer, Bank V set up a counterclaim for actual damages and litigation expenses. RC filed a motion to dismiss the counterclaim on the ground that Bank V's answer with counterclaim was not accompanied by a certification against forum shopping. A certification against forum shopping is required only in initiatory pleadings. In this case, the counterclaim pleaded in the defendant's answer appears to have arisen from the plaintiff's complaint or compulsory in nature and thus may not be regarded as an initiatory pleading. The absence thereof in the bank's answer is not fatal defect. Therefore, the motion to dismiss on the ground raised lacks merit and should be denied. USD versus Aurelia. On the other hand, if the counterclaim raised by the defendant bank answers was not predicated on the plaintiff's claim or cause of action, it is considered a permissive counterclaim, in which case it would partake an initiatory pleading which requires a certification against forum shopping. Correspondingly, the motion to dismiss based on lack of the required certificate against forum shopping should be granted. 2006. Honey filed with the RTC Taal Batangas a complaint for specific performance against Bernie for lack of certification against forum shopping. The judge dismissed the complaint. Honey's lawyer filed a motion for reconsideration, attaching thereto an amended complaint with the certification against form shopping. If you were the judge, how will you resolve the motion? If I were the judge, the motion should be denied after hearing because, as expressly provided in the rules, failure to comply with the required form shopping is not curable by mere amendment of the complaint or other initiatory pleading, but shall be cause for the dismissal of the case without prejudice, unless otherwise provided. Section 5, Rule 7. However, the trial court, in the exercise of its sound discretion, may choose to be liberal and consider the amendment as substantial compliance. Great Southern Maritime Services versus Acuna. 2000. As counsel for A, B, C, and D, attorney XY prepared a complaint for recovery of possession of a parcel of land against C. Before filing the complaint, XY discovered that his client were not available to sign the certification of form shopping. To avoid further delays in the filing of the complaint, XY signed the certification and immediately filed the complaint in court. Is XY justified in signing the certification? No. Counsel cannot sign the anti-form shopping certification because it must be executed by the plaintiff or principal party himself. Exocorpiso versus University of Baguio. Since the rule requires personal knowledge by the party executing the certification, unless counsel gives a good reason why he is not able to secure his client's signatures and shows that his clients will be deprived of substantial justice, Ortiz versus Court of Appeals, or unless he is authorized to sign it by his clients through a special power of attorney. Rule 8. Manner of making allegations in pleadings. 2018. V. Dorton Incorporated, Dorton for short, sued Deborah Commodities Incorporated, Deborah, Daniel, and Debbie in the RTC of Manila for recovery of sum of money. The complaint alleged that on October 14, 2017, Deborah obtained a loan from Dorton in the amount of $10 million with interest of 9% per annum. The loan was evidenced by a promissory note, payable on demand, signed by Daniel and Debbie, the principal stockholders of Deborah, who also executed a surety agreement binding themselves as sureties. Copies of both the PN, or the promissory note, and the surety agreement were attached to the complaint. Thornton further alleged that it made a final demand on March 1, 2018 for Deborah and the sureties to pay, but the demand was not heeded. Deborah, Daniel, and Debbie filed their answer and raised the affirmative defense that, while the promissory note and the surety agreement appeared to exist, Daniel and Debbie were uncertain whether the signatures of the documents were theirs. The PN and the surety agreement were pre-marked during pre-trial, identified but not authenticated during trial, and formally offered. Can the RTC of Manila consider the PN and the surety agreement in rendering its decision? Yes, the RTC of Manila may consider the PN and the surety agreement in rendering its decision. The PN and the surety agreement are actionable documents defined under Rule 8, Section 7 of the Rules of Court as a written instrument upon which an action is founded upon. Rule 8, Section 8, moreover, provides that when an action is founded upon a written instrument, copied in or attached to the corresponding pleading, the genuineness and due execution of the instrument shall be deemed submitted unless the adverse party, under oath, specifically denies them and sets forth what he claims to the facts. In this case, Deborah, Daniel, and Debbie are parties to the PN and the surety agreement. Since the PN and surety agreement are attached to the complaint, Deborah, Daniel, and Debbie are deemed to have admitted the genuineness and due execution thereof for their failure to A. deny the genuineness and due execution of these documents under oath, and B, to set for what they claim to be the facts. The court therefore may consider the PN and the surety agreement in rendering its decision. 2017. On the basis of an alleged promissory note executed by Harold in favor of Ramon, the latter filed a complaint for 950,000 pesos against the former in the RTC of Davao City. In an unverified answer, Harold specifically denied the genuineness of the promissory note. During the trial, Harold sought to offer the testimonies of the following: 1. The testimony of an NBI handwriting expert to prove the forgery of his signature, and 2. The testimony of a credible witness to prove that if ever Harold had executed the note in favor of Ramon, the same was not supported by a consideration. May Ramon validly object to the proposed testimonies? Ramon may validly object to the proposed testimony of the NBI handwriting expert. The alleged promissory note attached to Ramon's complaint is an actionable document since it is a written instrument upon which an action or defense is grounded. Asian Construction and Development Corporation versus Mendoza, GR 176949. Accordingly, Harold's failure to specifically deny under oath the genuineness of said actionable document amounts to an implied admission of its genuineness and due execution under Rule 8, Section 8 of the Rules of Court. Harold cannot thus raise the defense of forgery by presenting the testimony of a handwriting expert. While settled is the rule that the trial may reject evidence that a party adduces to contradict a judicial admission he previously made, since such admission is conclusive as to him. Equitable Code Network versus Capistrano. However, Ramon may validly object to the testimony of a credible witness to prove that the promissory note was not supported by a consideration. The admission of the genuineness and due execution of a document does not bar the defense of want of a consideration. Hebert versus Roth and Mac Milani, GRL 8414, 2005. In a complaint for recovery of real property, the plaintiff averred, among others, that he is the owner of the said property by virtue of a deed of sale executed by the defendant in his favor. A copy of the deed of sale was appended to the complaint as Annex A thereof. In his unverified answer, the defendant denied the allegation concerning the sale of the property in question, as well as the appended deed of sale, for lack of knowledge or information sufficient to form a belief as to the truth thereof. Is it proper for the court to render judgment without trial? Defendant cannot deny the sale of the property for lack of knowledge or information sufficient to form a belief as to the truth thereof. The answer amounts to an admission. The defendant must aver or state positively how it is that he is ignorant of the facts alleged. Philippines Advertising Counselors versus Aurelia, GRL 31869. Moreover, the genuineness of due execution of the deed of sale can only be denied by the defendant under oath, and failure to do so is also an admission of the deed. Section 8, Rule 8. Hence, a judgment on the pleadings can be rendered by the court without need of a trial. 2004. In his complaint for foreclosure of mortgage, which was duly attached a copy of the mortgage deed, plaintiff PP alleged inter alia as follows: 1. The defendant DD duly executed the mortgage deed, copy of which is annexed A of the complaint, and made an integral part thereof. And number 2, that to prosecute his complaint, plaintiff contracted a lawyer CC for a fee of 50,000. In his answer, defendant alleged inter alia that he had no knowledge of the mortgage deed, and he also denied any liability for plaintiffs contracting with the lawyer for a fee. This defendant's answer as to plaintiff allegation number 1 as well as number 2 sufficiently raise an issue of fact? Raising. As to plaintiff's allegation number 1, defendant does not sufficiently raise an issue of fact because he cannot allege lack of knowledge of the mortgage deed, since he should have personal knowledge as to whether he signed it or not, and because he did not deny under oath the genuineness and due execution of the mortgage deed, which is an actionable document. As to plaintiff allegation number 2, defendant did not properly deny liability as to plaintiff contracting with a lawyer for a fee. He did not even deny for lack of knowledge. Section 10, Rule 8. Rule 9, Effect of failure to plead. 2006. Joe J. filed with the Regional Trial Court of Laguna a complaint for damages against Joe. During the pre-trial, Joe and his counsel failed to appear despite notice to both of them. Upon oral motion of Joji, Joe was declared as in default and Joji was allowed to present her evidence ex parte. Therefore, the court rendered its decision in favor of Joji. Joe hired Jose as his counsel. What are the remedies available to him? Before the rendition of judgment. Before the rendition of judgment, he may file a motion under oath to set aside the order of default on the ground of fraud, accident, mistake, or excusable negligence, and that he has a meritorious defense. Rule 3, letter B, Rule 9. And if it is denied, he may move to reconsider. And if reconsideration is denied, he may file the special civil action of certiorari for grave abuse of discretion, tantamount to lack or excess of the lower court's jurisdiction. Rule 1, Rule 65, Section 1. Or he may file a petition for certiorari if he has been illegally declared in default. That is, during the pendency of his motion to dismiss or before the expiration of the time to answer. Matute versus Court of Appeals. Costa Ofalia versus Sundiam. How about after judgment but before its finality? After judgment but before its finality, he may file a motion for new trial on the ground of fraud, accident, mistake, excusable negligence, or a motion for reconsideration on the ground of excessive damages, insufficient evidence, or the decision or final order being contrary to law. Section 2, Rule 27, and thereafter, if the motion is denied, appeal to available under Rules 40 or 41, whichever if applicable. After finality of judgment. After finality of judgment, there are 3 ways to assail the judgment, which are 1. A petition for relief under Rule 38 on the grounds of fraud, accident, mistake, or excusable negligence. Number 2, annulment of judgment under Rule 47 for extrinsic fraud or lack of jurisdiction. Or certiorari if the judgment is void in its face or by the judicial record. Balancat versus Justices of the Court of Appeals. 2001. Mario was declared in default, but before judgment was rendered, he decided to file a motion to set aside the order of the default. What should Mario state in his motion in order to justify the setting aside of the order of default? And what form should such motion be? In order to justify the setting aside of the order of default, Mario should state in his motion that his failure to answer was due to fraud, accident, mistake, or excusable negligence, and that he has a meritorious defense. Section 3, letter B of Rule 9. The motion should be under oath. 2003, A filed with the MTC of Manila an action for special performance against B, a resident of Quezon City, to compel the latter to execute a deed of conveyance covering a parcel of land situated in Quezon City, having an assessed value of 19,000. B received the summons and a copy of the complaint on January 2, 2003. On January 10, 2003, B filed a motion to dismiss the complaint on the ground of lack of jurisdiction, contending that the subject matter of the suit was incapable of pecuniary estimation. The court denied the motion. In due time, B filed with the RTC a petition for certiorari, praying that the said order be set aside because the MTC had no jurisdiction over the case. On February 13, 2003, A filed with the MTC a motion to declare B in default. The motion was opposed by B on the ground that his petition for certiorari was still pending. Was the denial of the motion to dismiss the complaint correct? The denial of the motion to dismiss the complaint was not correct. Although the assessed value of the parcel of land involved was 19,000 within the jurisdiction of the MTC of Manila, the action filed by A for specific performance against B to compel the latter to execute a deed of conveyance of said parcel of land was not capable of pecuniary estimation, and therefore the action was within the jurisdiction of the RTC. Russell v. Vestil, Copioso versus Copioso, Kabutihan versus Land Center Construction. Resolved the motion to declare the defendant in default. The court could declare B in default because B did not obtain a writ of preliminary injunction or a temporary restraining order from the RTC prohibiting the judge from proceeding in the case during the pendency of the petition for certiorari. Section 7 of Rule 65, Diaz versus Diaz. Alternative answer. The court should not declare B in default inasmuch as the jurisdiction of MTC was put in issue in the petition for certiorari filed with the RTC. The MTC should defer further proceedings pending the result of such petition. Eternal Gardens Memorial Park versus Court of Appeals. 2002, the plaintiff sued the defendant in the RTC for damages allegedly caused by the latter's encroachment on the plaintiff's lot. In his answer, the defendant denied the plaintiff's claim and alleged that it was the plaintiff who in fact had encroached on his defendant's land. Accordingly, the defendant's counterclaim against the plaintiff for damages resulting from the alleged encroachment on his lot. The plaintiff filed an ex parte motion for extension of time to answer the defendant's counterclaim, but the court denied the motion on the ground that it should have been set for hearing. On the defendant's motion, therefore, the court declared the plaintiff in default on the counterclaim. Was the plaintiff validly declared in default? No, the plaintiff was not validly declared in default. A motion for extension of time to file an answer may be filed ex parte and need not be set for hearing. Amante versus Sunga. Alternative answer. The general rule is that a counterclaim must be answered within 10 days from service. Rule 11, Section 4. However, a counterclaim that raises issues which are deemed automatically joined by the allegations of the complaint need not be answered. Gojo versus Goyola. In this case, the defendant's counterclaim is a compulsory counterclaim which arises out or is connected with the transaction and occurrence constituting the subject matter of the plaintiff's claim. It raises the same issue of who encroached on whose land. Hence, there was no need to answer the counterclaim. 2000. For failure of KJ to file an answer within the reglementary period, the court upon motion of LM declared KJ in default. In due time, KJ filed an unverified motion to lift the order of default without an affidavit of merit attached to it. KJ, however, attached to his motion his answer under oath, stating in said answer his reasons for his failure to file an answer on time, as well as his defenses. Will the motion to lift the order of default prosper? Yes, there is substantial compliance with the rule. Although the motion is unverified, the answer attached to the motion is verified. The answer contains what the motion to lift the order of default and the affidavit of merit should contain, which are the reasons of movant's failure to answer as well as his defenses. Section 3, letter B of Rule 9 of 1997 Rules of Civil Procedure. Citibank N.A. versus Court of Appeals. 2000, defendant was declared in default by the RTC. Plaintiff was allowed to present evidence in support of his complaint. Photocopies of official receipts and original copies of affidavits were presented in court, identified by plaintiff on the witness stand and marked as exhibits. Said documents were offered by plaintiff and admitted in evidence by the court, on the basis of which the RTC rendered judgment in favor of the plaintiff, pursuant to the relief prayed for. Upon receipt of the judgment, defendant appeals to the Court of Appeals claiming that the judgment is not valid because the RTC based its judgment on mere photocopies and affidavits of persons not presented in court. Is the claim of defendant valid? The claim of defendant is not valid. Under the 1997 rules, reception of evidence is not required. After a defendant is declared in default, the court shall proceed to render judgment granting the claimants such relief as his pleading may warrant, unless the court in its discretion requires the claimant to submit evidence which may be delegated to the clerk of court. Alternative answer. The claim of defendant is valid because the court received evidence which it can order in its own discretion, in which case the evidence of the plaintiff must pass the basic requirements of admissibility. 1999. When may a party be declared in default? A party may be declared in default when he fails to answer within the time allowed therefor, and upon motion of the claiming party, with notice to the defending party and proof of such failure. Rule 9, Section 3. What is the effect of an order of default? The effect of an order of default is that the court may proceed to render judgment granting the claimant such relief as his pleading may warrant, unless the court in its discretion requires the claimant to submit evidence. The party in default cannot take part in the trial but shall be entitled to notice of subsequent proceedings. For failure to reasonably file his answer despite due notice, A was declared in default in a case instituted against him by B. The following day, A's mistress, who is working as a clerk in the salo of the judge before whom his case is pending, informed him of the declaration of default. On the same day, A presented a motion under oath to set aside the order of default on the ground that his failure to answer was due to fraud, and he has a meritorious defense. Thereafter, he went abroad. After his return a week later, with the case still undecided, he received the order declaring him in default. The motion to set aside default was opposed by B on the ground that it was filed before A received notice of his having been declared in default, citing the rule that the motion to set aside may be made at any time after notice but before judgment. Resolve the motion. Assuming that the motion to set aside complies with the other requirements of the rule, it should be granted, although such a motion may be made after notice but before judgment. Section 3, letter B of Rule 9, with more reasons may be filed after discovery even before receipt of the order of default. What are the available remedies of a party declared in default before the rendition of judgment? He may file a motion under oath to set aside the order of default on the ground of fraud, accident, mistake, or excusable negligence, and that he has a meritorious defense. Section 3, letter B, Rule 9. And if it is denied, he may move to reconsider, and if the reconsideration is denied, he may file the special civil action of certiorari for grave abuse of discretion tantamount to lack or excess of the lower court's jurisdiction. That is Rule 65, Section 1, and he may file a petition for certiorari if he has been illegally declared in default, that is, during the pendency of his motion to dismiss or before the expiration of the time to answer. Matute versus Court of Appeals. Now, after judgment, but before its finality, and this is a repeat, he may file a motion for new trial on the grounds of fraud, accident, mistake, excusable negligence, or motion for reconsideration on the ground of excessive damages, insufficient evidence, or the decision or final order being contrary to law. And thereafter, if the motion is denied, appeal to available under Rules 40 or 41, whichever is applicable. Now, after finality of judgment, there are three ways to assail the judgment, which are petition for relief under Rule 38 on the ground of fraud, accident, mistake, or excusable negligence, annulment of judgment under Rule 47 for extrinsic fraud or lack of jurisdiction, or certiorari if the judgment is void on its face or by the judicial record. Balangkad versus Justices of the Court of Appeals. Rule 10, Amended and Supplemental Pleadings, 2008. Arturo lent $1 million to his friend Robert on the condition that Robert execute a promissory note for the loan and a real estate mortgage over his property located in Tagaytay City. Robert complied. In his promissory note dated September 20, 2006, Robert undertook to pay the loan within a year from its date at 12% per annum interest. In June 2007, Arturo requested Robert to pay ahead of time, but the latter refused and insisted on the agreement. Arturo issued demand letters, and when Robert did not comply, Arturo filed an action to foreclose the mortgage. Robert moved to dismiss the complaint for lack of cause of action as the debt was not yet due. The resolution of the motion to dismiss was delayed because of the retirement of the judge. On October 1st, 2007, pending resolution of the motion to dismiss, Arturo filed an amended complaint alleging Robert's debt had in the meantime become due, but that Robert still refused to pay. Should the amended complaint be allowed considering that no answer has been filed? No, the complaint may not be amended under the circumstances. A complaint may be amended as of right before answer. Rule 2, Section 2, Rule 10, Ongpeng versus Custodio. GR 121397, April 17, 1997, citing Prudence, Realty, and Development. But the amended should refer to facts which occurred prior to the filing of the original complaint. It thus follows that a complaint whose cause of action has not yet accrued cannot be cured or remedied by an amended or supplemental pleading alleging the existence or accrual of a cause of action while the case is pending. Swagman, Hotels and Travel versus CA. Would your answer be different had Arturo filed instead a supplemental complaint stating that the debt became due after the filing of the original complaint? A supplemental complaint may be filed with leave of court to allege an event that arose after the filing of the original complaint that should have already contained a cause of action. Section 6, Rule 10. However, if no cause of action is alleged in the original complaint, it cannot be cured by the filing of a supplement or amendment to allege the subsequent acquisition of a cause of action. 2005. On May 12, 2005, the plaintiff filed a complaint in the RTC of Quezon City for the collection of $250,000. The defendant filed a motion to dismiss the complaint on the ground that the court had no jurisdiction over the action, since the claimed amount of $250,000 is within the exclusive jurisdiction of the Metropolitan Trial Court, or Quezon City. Before the court could resolve the motion, the plaintiff, without leave of court, amended his complaint to allege a new cause of action consisting in the inclusion is an additional amount of $200,000, thereby increasing his total claim to $450,000. The plaintiff thereafter filed his opposition to the motion to dismiss, claiming that the RTC had jurisdiction over his action. Rule on the motion of the defendant with reasons. The motion to dismiss should be denied. Basic is the rule that a motion to dismiss is not a responsive pleading. Under the rules, a pleader may amend his pleading as a matter of right before the other party has served his responsive pleading. Section 2, Rule 10. The court, in allowing the amendment, would not be acting without jurisdiction because allowing an amendment as a matter of right does not require the exercise of discretion. The court, therefore, would not be acting and thus could not have acted without jurisdiction. It would have been different had the amendments been made after a responsive pleading had been served. The court then would have been exercising its discretion in allowing or disallowing the amendment. It cannot do so, however, because it would be then acting on an amendment of a complaint over which has no jurisdiction. Soledad versus Mamangun. Kumabay versus Barilan. Prudence Realty versus CA. Alternative answer: the motion to dismiss should be granted. Jurisdiction must be conferred by the contents of the original complaint. Amendments are not proper and should be denied where the court has no jurisdiction over the original complaint, and the purpose of the amendment is to confer jurisdiction on the court. Rosario versus Carandang. While a plaintiff is entitled to amend the complaint before a responsive pleading is served, Section 2, Rule 10, still, a complaint cannot be amended to confer jurisdiction on a court where there was none to begin with. 2004, during trial, plaintiff was able to present without objection on the part of the defendant in an ejectment case evidence showing the plaintiff served on defendant a written demand to vacate the subject property before the commencement of the suit, a matter not alleged or otherwise set forth in the pleadings on file. May the corresponding pleading still be amended to conform to the evidence? Yes, the corresponding pleading may still be amended to conform to the evidence because the written demand to vacate made prior to the commencement of the ejectment suit was presented by the plaintiff in evidence without objection on the part of the defendant. Even if the demand to vacate was jurisdictional, still the amendment proposed was to conform to the evidence that was already in the record and not to confer or jurisdiction on the court, which is not allowed. Failure to amend, however, does not affect the result of the trial on these issues. Alternative answer: it depends. In forcible entry, the motion may be allowed at the discretion of the court, the demand having been presented at the trial without objection on the part of the defendant. In unlawful detainer, however, the demand to vacate is jurisdictional, and since the court did not acquire jurisdiction from the very beginning, the motion to conform to the evidence cannot be entertained. The amendment cannot be allowed because it will affect conferred jurisdiction when there is otherwise no jurisdiction. 2003, after an answer has been filed, can the plaintiff amend his complaint with leave of court by changing entirely the nature of the action? Yes. The present rules allow amendments substantially altering the nature of the cause of action. Section 3, Rule 10. Years of Marcelino Pagobo versus Court of Appeals. This should only be true, however, when the substantial change or alteration in the cause of action or defense shall serve the higher interests of substantial justice and prevent delay and equally promote the laudable objective of the rules, which is to secure a just, speedy, and inexpensive disposition of every action and proceeding. Valenzuela versus Court of Appeals. 2000. X, an illegitimate child of Y, celebrated her 18th birthday on May 2, 1996. A month before her birthday, Y died. The legitimate family of Y refused to recognize X as an illegitimate child of Y. After countless efforts to convince them, X filed on April 25, 2000, an action for recognition against Z, wife of Y. After Z filed her answer on August 14, 2000, X filed a motion for leave to file an amended complaint and a motion to admit that said amended complaint in pleading the three legitimate children of Y. The trial court admitted the amended complaint on August 22, 2000. What is the effect of the admission of the amended complaint? Has the action of X prescribed? No. The action filed on April 25, 2000 is still within the 4-year prescriptive period, which started to run on May 2, 1996. The amended complaint in pleading the 3 legitimate children, though admitted on August 22, 2000, beyond the 4-year prescriptive period, retroacts to the date of filing of the original complaint. Amendments in pleading new defendants retroact to the date of filing of the complaint because they do not constitute a new cause of action. Versosa versus Court of Appeals. Alternative answer: under the 1997 Rules of Civil Procedure, if an additional defendant is impleaded in a later pleading, the action is commenced with regard to him on the date of the filing of such later pleading, irrespective of whether the motion for its admission, if necessary, is denied by the court, Section 5 of Rule 1. Consequently, the action of X has prescribed with respect to the 3 legitimate children of Y who are indispensable parties. Another alternative answer: under Article 175 of the Family Code, the action must be brought within the lifetime of X if the action is based on record of birth or an admission of filiation in a public document or a private handwritten instrument signed by Y. In such case, the action of X has not prescribed. However, if the action is based on the open and continuous possession of the status of an illegitimate child, the action should have been brought during the lifetime of Y. In such case, the action of X has prescribed. Rule 11, when to file responsive pleadings. Rule 12, Bill of Particulars. 2018. The Republic of the Philippines filed a complaint with the Sandigan Bayan in connection with the sequestered assets and properties of demo companies, or demo for short, and impleaded its officers and directors. Since the complaint did not include demo as defendant, the Sandigan Bayan issued a resolution where it ordered demo to be impleaded. Thereafter, the Republic filed an amended complaint naming demo as additional defendant, which amendment was later admitted. Demo filed a motion for Bill of Particulars for the Republic to clarify certain matters in its amended complaint. The Sandigan Bayan immediately granted the motion. Upon submission of the Bill of Particulars by the Republic, Demo filed a motion to dismiss, arguing that the answer in the Bill of Particulars were indefinite and deficient responses to the question of what the alleged illegally acquired funds or properties of Demo were. The Sandigan Bayan dismissed the case. Was the Sandigan Bayan correct in dismissing the case? No. The Sandigan Bayan is incorrect in dismissing the case. An action cannot be dismissed on the ground of vagueness or indefiniteness. Galion versus Galion. Alternative answer: yes, the Sandigan Bayan was correct in dismissing the case under Rule 2, Section 4 of the Rules of Court. The consequence of insufficient compliance with a court order for a Bill of Particulars or a more definite pleading is that the court may order the striking out of said pleading or the portions thereof. In this case, the Sandigan Bayan dismissed the case upon non-compliance with its order for a definite pleading. The dismissal of the case was made by the striking out of the pleading, which in this case, the complaint by the Republic. In striking out said pleading, no complaint existed, thus the Sandigan Bayan effectively dismissed the case. The Sandigan Bayan therefore correctly dismissed the case as the Bill of Particulars were deemed insufficient, leading to the striking out of the complaint. What can the defendant in a civil case do in the event that his motion for a Bill of Particulars is denied? Under Rule 12, Section 5 of the Rules of Court, after notice of denial of his motion, the moving party may file his responsive pleading within the period to which he was entitled at the time of filing his motion, which shall not be less than 5 days in any event. If tainted with grave abuse of discretion, the moving party may question the denial through a Rule 65 certiorari. 2008. Within the period of filing a responsive pleading, the defendant filed a motion for a bill of particulars that he set for hearing on a certain date. However, the defendant was surprised to find on the date set for hearing that the trial court had already denied the motion on the day of its filing, stating that the allegations of the complaint were sufficiently made. Did the judge gravely abuse his discretion in acting on the motion without waiting for the hearing set for the motion? There is no need to set the motion for hearing. The duty of the clerk of court is to bring the motion immediately to the attention of the judge, who may act on it at once. If the judge grants the motion and ordered the plaintiff to file and serve the bill of particulars, can the trial judge dismiss the case if the plaintiff does not comply with the order? Yes. The judge may dismiss the case for failure of the plaintiff to comply with its order, or order the striking out of the pleading, as may issue any other order at its discretion. Section 4, Rule 12. When can a bill of particulars be availed of? What is the effect of noncompliance with the order of a bill of particulars? Asked 2003. Before responding to a pleading, a party may move for a bill of particulars of any matter which is not averred with sufficient definiteness or particularity to enable him properly to prepare his responsive pleading. If the pleading is a reply, the motion must be filed within 10 days from service thereof. If the order is not complied with, the court may order the striking out of the pleading or the portions thereof to which the order was directed, or make such other order at its discretion. Rule 13. Filing of service of pleading, judgment, and other papers. Rule 14. Summons. 2016. Tristan filed a suit with the RTC of Pasay against Arthur King and or estate of Arthur King for reconveyance of a lot declared in the name of Arthur King under TCT number 1234. The complaint alleged that on account Arthur King's residence abroad up to the present and the uncertainty of whether he is still alive or dead, he or his estate may be served with summons by publication. Summons was published and nobody filed any responsive pleading within 60 days therefrom. Upon motion, defendant were declared in default and judgment was rendered declaring Tristan as legal owner and ordering defendant to convey said lot to Tristan. Jojo, the court-designated administrator of Arthur King's estate, filed a petition for annulment of judgment before the CA, praying that the decision in favor of Tristan be declared null and void for lack of jurisdiction. He claims that the action filed by Tristan is an action in personam and that the court did not acquire jurisdiction over defendant Arthur King or his estate. On the other hand, Tristan claims that the suit is an action in rem, or at least an action quasi in rem. Is the RTC judge correct in ordering service of summons by publication? Yes, the RTC judge is correct in ordering the service of summons by publication. In action for declaring of nullity of title and recovery of ownership of real property, or reconveyance is a real action, but it is an action in personam, for it binds a particular individual only although it concerns the right to a tangible thing. Any judgment therein is binding only upon the parties properly impleaded, which is heirs of Eugenio Lopez versus Enriquez cited in Emerita Munoz versus Attorney Victorino. In an action in personam, jurisdiction over the person of the defendant is necessary for the court to validly try and decide the case. Jurisdiction over the person of a resident defendant who does not voluntarily appear in court can be acquired by personal service of summons as provided under Section 7, Rule 14. If he cannot be personally served with summons within a reasonable time, substituted service may be made in accordance with Section 8. Under Section 14, Rule 14, Rules of Court, in any action where the defendant is designated as an unknown owner or the like, or whenever his whereabouts are unknown and cannot be ascertained by diligent inquiry, service may by leave of court be effected upon him by publication in a newspaper of general circulation, and in such places and for such time as the court may order. This rule applies to any action, whether in personam, in rem, or quasi in rem. Pedro T. Santos versus PNOC Exploration Corporation. Clearly, since the action for reconveyance is an action in personam, the RTC judge is correct in ordering service of summons by publication. Alternative answer, no. The RTC judge is not correct in ordering service of summons by publication. It is a well-settled rule that in an action in personam, wherein the defendant is a non-resident who does not voluntarily submit himself to the authority of the court, personal service of summons within their state is essential to the acquisition of jurisdiction over her person. This method of service is possible if such defendant is physically present in the country. If it is not found therein, the court cannot acquire jurisdiction over his person and therefore cannot validly try and decide the case against him. Spouses Domingo M. Belen et al. Versus Honorable Pablo Chavez. Accordingly, the RTC judge is not correct in ordering service of summons by publication.